women having breast cancer, and maybe we need to screen, that we need to have a different outcome. So we've had some really great ones this year. I'm excited about this one, and here we go. So Julie, I'll start with you. Julie, I got to meet at a conference here in Houston, and we got sitting next to each other at dinner, and it's like old home week. So we had a really great time, and I'd love for Julie to introduce herself, and you all tell us what exactly it is you do in your practice. I think I don't even really have a concept of that, and we'll get going here. So Julie,
sounds good. Hi everybody, and thank you so much for the invite, Kristen and Catherine. I'm Julie Selesnick, senior counsel at Berger, Montague, a law firm it's headquartered in Philadelphia. I'm in the Washington D.C. area, and I'm 100% focused on health plans and all of the business of health plan administration. Half of my practice is focused on litigation, and we currently bring class action lawsuits against insurance carriers trying to get access to data, and also for overpayment recovery and things like that, and for deceptive business practices when we bring the cases under state law. And then the other half of my practice has turned into a sort of a consulting practice where I consult to plans, advisors, and vendors that are just trying to compete and get a level playing field and find a way to sort of not be squeezed out by the large insurance companies and the huge hospital systems, and find a way to, bring lower cost, better value options to health plans and participants.
Excellent. And then I remember meeting Doug several years ago, pre-COVID, at a conference, and he's a fellow Texan these days. Doug, would you like to introduce yourself?
Sure, absolutely. So my name is Doug Aldeen. I've been a lawyer actually now for 32 years. Been in healthcare since '97, so I've seen a lot from, HMOs and capitation to, what's currently going on in the market. My practice is primarily, I work with a lot of level-funded health plans. A couple of startups. I saw Raju is on the call, so I do a lot of work with Raju in Homa Health, and then large claim resolution. So whether it's a TPA, whether it's a self-funded plan, just kind of help them untangle what got tangled.
Fantastic. So that gives us a little different perspective on this, and I'm not seeing Chris on, so we'll go ahead and move ahead. So I wanted to start with, ERISA law has been around a long time, since 1974. But the feeling was it had no teeth until the CAA came around. I have a couple of questions here, and we'll start with you, Julie. Why did it have no teeth? What was the problem? And then I recently learned that some of these health plans aren't covered by ERISA. And so who is not covered by ERISA, and what happens with fiduciary duty in that setting?
All right. So first, as a longtime ERISA practitioner, I feel sad to hear ERISA has no teeth. It does have teeth, and it always did have teeth. It just wasn't designed to deal with the healthcare system. And really, in 1974, when it was written and created, it was more designed to deal with the financial aspect of holding plan assets in trust, and with pensions and things like that, to protect employee assets. And it was specifically given teeth by Congress by allowing participants to go ahead and bring lawsuits, not only on their own behalf, but on behalf of the plan. Now, unfortunately, the courts have kind of ruined that portion of ERISA. And now you really can't bring a claim on behalf of a plan unless you are personally injured. That is what the courts have done to ERISA, to sort of erode the ability to bring lawsuits. And again, it has had a lot of teeth in the pension and 401k space, as you can see from there's been litigation going on for 20 years. It's really cleaned up sort of an excessive fee issue that used to go on inside of 401k portfolios and places like that. But in healthcare, it just doesn't work the same. That's the CAA was passed sort of as an acknowledgement that there's something missing here. It doesn't work as well for health plans, because to be a proper fiduciary, you need to be able to monitor the service providers you hire. You need to review, data, and you have been unable historically to do that in health plans. So the CAA, the passage of the CAA was like, let's make things a little more fair here and have them work like they work on the pension side. So first of all, let's make sure that plans are getting claims data, that they have access to claims data. Let's make sure that they know the compensation, direct and indirect, that they're paying their brokers, consultants, and other plan covered service providers. So this is what the law says. Whether or not this has worked out so far is another matter, but this is what's supposed to happen. Is it was supposed to give plans access to claims data, the ability to understand what they're paying all of their service providers to make sure there's no conflicts of interest, and to just ensure proper plan management and that claims are being adjudicated properly. So that's what's necessary to make ERISA work and have teeth. And we're still obviously trying to make those laws work against a really hostile backdrop. For your second question, so ERISA covers all employer-sponsored health plans that are private. So non-governmental, employer-sponsored health plans. There are a large number of non-ERISA covered plans as well, which would be church plans. That's a small category, which are plans that are sort of carved out because they're created by a church or on behalf of a church or for a group of churches by the federal government. They're not subject to ERISA. And then the third really big category is non-federal governmental health plans. And that's like municipalities, states, school boards, things like that. In most cases, they are also fiduciary duties that are incumbent with those plans. And they're either fiduciaries by law, named in the trust as fiduciaries, or they have responsibilities that are akin to fiduciary responsibilities because they're responsible for taxpayer dollars.
That was one of the things I found really interesting because so many of our clients fall into that category.
Oh, yeah.
They're the ones who are kind of first movers, or a lot of the school districts and indigenous tribes. And, it's been really fascinating to me to learn that piece. Okay, Doug, you want to expand on that?
I was going to just provide a real example just recently. So I was working with the TPA in Texas. As Kristen, as you know, and Jill, you may not, but South Texas is inherently corrupt. But a broker approached the TPA, basically, demanding a 3% commission on network fees, under the table, if you will, because it's a school district, and exempt from ERISA. But you run into things like that because, to me, I think there's a whole another layer of things that are happening in the market with those governmental plans, especially school districts. I don't know, Jill, if you've seen that at all, but
well, what I've seen is school districts getting really fed up. And I think the Osceola County situation a few years back was sort of eye-opening to some of them. And we do have school districts that are now trying to, the ironic thing about the CAA is that the broker disclosures, the compensation disclosures, that's the only section that doesn't apply outside of ERISA. And, I talk to municipalities and health plans, school boards, and they're like, well, this doesn't apply to me. I'm like, well, trust me, as a shepherd of taxpayer funds, you should also know what you're paying vendors for your health plan and whether or not it's reasonable.
Exactly.
Yeah. So that's how I see it, as them trying to sort of empower themselves to get a handle on this now.
And for those of you who don't know about the School District of Osceola County case, we were brought in 2019 to do a claims data assessment for that district. And what we found was there were hundreds of claims that were billed out without a CPT code, with just a hospital revenue code, paid out, with paid out for MRIs and CTs, paid out up to $40,000. And so, they have been a client of ours for the past, 5 years now. And they have literally saved millions and millions and millions of dollars. It's probably in the 50 million range. And, that I had, when I was presenting that case study at a panel, somebody, it was a group like this, and somebody, put into the chat that, if they had that money that we saved in 1 year, they could have kept the school open. That's how consequential that is. And the other thing that was so important there was that the employees they had a $4,000 deductible and then a $6,000 maximum out of pocket with a 50% co-insurance in between.
Yeah, you're upside down. You can't even really access your insurance.
Right. Mm-hmm. They were functionally uninsured. Yeah. You're exactly right, Doug. So then, I would say my next question, we'll start with you, Doug. What is the most significant lawsuit you've seen in this space to date? And what would be the perfect fiduciary duties?
Well, I would say this. I mean, I'm going to give you like a 30,000 foot view. I mean, I'm really keen on the Wells Fargo Aon connection. And, Julie, you're much more in the details in the weeds than I am. But to me, both lawsuits that have been filed, Aon is the broker. And so, there's a pattern developing here. So if I was in this market looking for these types of cases, I'm definitely looking to see where Aon is, parked. Julie, what do you think?
I would also be sweating right now if I was Aon, not named yet, but discussed in both the Wells Fargo and the J&J lawsuit, and discussed much more in the Wells Fargo lawsuit. It looks like, if you look at the evolution of these suits, you can see that at some point Aon looks like they're going to be on the menu too. But I would also argue that probably what Aon is doing and has done is no different than what any of the big brokers do and continue to do. So I wouldn't, be laughing in the corner if I was Willis Towers Watson or Mercer or Gallagher either, because it's just the way the business practices across, have been, the way they've done business across the board has to change. And what they consider sort of the normal way of doing business is what's under attack right now.
Exactly.
So that brings us to, Julie, who are the fiduciaries of an employer health plan?
So the people that are fiduciaries, whoever signed the 5,500, that's a fiduciary. If someone's named the responsible fiduciary in the plan documents, they're a fiduciary. If someone's on the health and welfare committee, fiduciary committee, they're fiduciaries, or any sort of health and welfare committee for a company, they're likely all fiduciaries. But then there's a whole nother category of people so that's the officially named fiduciary category. Then there's functional fiduciaries in ERISA. You don't have to be named as a fiduciary. Anyone who's exercising discretion or is given discretion, whether they exercise it or not, over the administration or management of the plan, or if they have the ability to direct the use of plan assets, anyone who can do any of those things is a fiduciary as well. Which is why we often bring litigation against insurance carriers and say, for this thing we're litigating, you're a fiduciary for this because you are exercising discretion in this particular area, or you're using plan assets in this particular area. So we think that there are arguments and that are, successful in some courts, unsuccessful in others, that you can be a functional fiduciary for specific purposes, and that doesn't make you one across the board. And we argue that a lot.
So,
and another thing, I was going to supplement what Julie just said. I mean, if I was an employer, I mean, the first thing I would do is, do I even have fiduciary coverage? And if so, what amount? Because a lot of organizations don't. And even if they do, I would argue it's probably not enough, just because of the dollars that are, floating between the RX and medical. Yeah,
and
it
the
would
right
not
thing
be
to do
sufficient.
there. And make sure you name your employees that are acting as fiduciaries on those policies, and then have a catch-all for anyone that you employ or give discretion to that is doing things for your plan. Because if you noticed in Wells Fargo, J&J, they're naming the individual fiduciaries in the lawsuit. And the worst that your job already, many people aren't very happy with their jobs when they find out they have to, run a health plan, and then to get sued for it, that's just terrible. So it's really important that employers protect their employees.
I think that's one of the most important pieces. And Doug, what are you finding? Are you finding that, say, the HR people who are on the fiduciary duty committee are aware of their duty?
No. I mean, I listen, this is like the Great Awakening. I mean, I think so many people have been asleep at the wheel. I mean, I think the old adage is nobody ever gets fired for, hiring Blue Cross Blue Shield. And, you just been doing the same thing over and over again. And now all of a sudden, people are turning over these stones and realizing, holy cow, what has been happening here? I think a lot of people truly don't understand the situation they're in. Julie, would you agree with that?
Absolutely. And I think that, what employers don't understand is it's great to name people to a fiduciary committee, or you're going to have a committee for your health plan. But if you don't tell them what they're supposed to be doing and don't train them and what their obligations are, then they're only as good as what they know. People don't just wake up and know how to be a good fiduciary. They require training and education. So it's really important to provide that as an employer to the people that are running your health plan if you don't want to be targeted in a future lawsuit.
So maybe,
Yep.
one of the strategies needs to be that SHRM and some of these entities really get on the bandwagon about educating. I find that, the people that we are working with in kind of our ecosystem are pretty aware of it, but when the HR people come in the door, they're just blindsided by this. Would you all agree with that?
Oh
Absolutely.
yeah.
Okay. So let's talk about kind of the next step. You're on a committee. What are your, what's your checklist? What should you be looking at? Doug, I'll let you start with this, but if you were, advising a committee and starting to give them, and maybe this is one of the, I know Health Rosetta is coming out with a lot of new open source materials. And so, this may be something that they're working on, but what should that checklist look like?
Boy, I listen. I'm not a big fan of do it yourself. I mean, hire the pros. And so there's a lot of people in the market who, understand exactly what needs to be happening. I've got a client actually in Cleveland, Ohio called Risk International. They do this for all the private equity firms. So anytime bank takes over a portfolio of companies, I mean, they just have one guy says fix it, and you go through a list. You gotta, that list, I don't want to say it's exhaustive, but it's, details matter. You got to know the right questions to ask, where are the dollars flowing? I mean, it's a pretty complicated process, Julie. Wouldn't you agree with that?
Oh yeah. I think it's really complicated.
Yeah.
And I think that you have to, the most important thing if you have your fiduciary committee to have is a process put into place that they follow to make all important fiduciary decisions under the health plan.
Yeah.
So, if you go back to the basics, you've got two duties as a fiduciary, a duty of prudence and a duty of loyalty. Duty of prudence is to, act as a reasonable person that understands the area that they're in, make decisions like they would make. So that means exactly what Doug just said, that if you don't know what you're doing when it comes to figuring out how to make your PBM formulary, you need to hire somebody who can help you with that. And then you need to make sure that here's your duty of loyalty, that the person you hire is non-conflicted, that they're not receiving money from the PBM that they recommend you go with. And this is what we're seeing in the complaints where people bring up Aon and things like that. So that they the duties fold into each other, but it's always the same two things. You got to spend money prudently. You can't just be wasting money, and you should be spending money only to pay for plan benefits and to defray reasonable costs. And you just need to make sure that there are no loyalty issues in all of these transactions. So you can do that by creating a process by which all of these decisions are made. So let's see, we haven't, done an RFP for our broker in 5 years. I think it's time to do that. Let's follow our process starting at step 1. And you can follow the same 10 steps, every decision like this, once you create them. So you just need to create a process you're going to follow every time you have these big fiduciary decisions that you need to make. Also important, meet regularly, at least quarterly, but I recommend more. I think it's really smart. I cannot enough echo what Doug said about hire people who know what they're doing. And that might mean getting an outside person to sit on your committee as an outside fiduciary who can advise you, particularly at the beginning where people really don't know what they're supposed to be doing. Make sure you give fiduciary training to that committee, and just make sure that you're keeping things fresh. You know what all your disclosure obligations are. You know when you're supposed to be doing RFPs, when plan documents need to be updated, and that these things all follow the same process when you do them.
Exactly.
A really important point, which is, claims data is key to a lot of this. And even the analytics companies don't do some of it properly. I would say, number one, don't believe what the business give you, because we had a Fortune 500 company that we did the analysis on the imaging claims data, and Aetna did it. Aetna said it was 6% of their spend. We said it was 11% of their spend. So they get Aetna on the phone. And so, I ask, where are the, the HCPCS codes? Where are these radiopharmaceuticals, contrast, all of those codes? Oh, they're over in pharmaceuticals. They're not pulled in. And then the second is where the professional fees. Oh, they're over with the provider services. And so all of that was not being rolled into imaging. The only thing that was going into imaging was the facility fees. And so you've got to, you need a true expert, not only And, not only the data, but you need somebody who knows how to go, put that data back together. And so we talk about complicated. It is really complicated. I think the people who can do imaging claims data analysis, they're probably who do it properly. So that's a really good point. Okay, I have an interesting question, and that is that we have a tremendous lack of understanding of healthcare literacy in this country. Not only healthcare literacy, but how to navigate the system. Does an employer have a duty to educate health plan members in either of those areas?
Yeah, boy, Jill, I don't think that an employer really has a duty to help navigate the system. And I think you have to make sure the dollars flow consistent with, the employer's obligations. But I don't think there's an obligation that extends to, helping your employees navigate the system. I mean, that could be something you could try to help, but I don't think there's an obligation. What do you think?
I think that where we are today, right now, there's no such obligation. But I think as the law evolves in this area, we're going to see obligation. So I do think there's an obligation to spend plan dollars wisely. And I think that one of the problems that we currently have in the self-funded world and in the fully insured world, is the inability for plans to steer patients towards the most cost-effective providers, because the insurance company and their network made an agreement that that's not allowed. And now an employer is bound by this and cannot direct its employee to something that might be better value, better quality, lower cost. And so that to me is long-term problematic. But I don't think it's even anywhere close to the radar screen. I think everyone needs to understand that Congress and the courts are like so far back on their understanding of what everyone is dealing with in real life. And they're still asking, like my colleague Karen, she was asked to come in and explain after this congressional committee read the reporting about multi-plan, to tell them what repricing was, because they just were shocked by the reporting and they weren't sure it was even real. Like they needed more understanding of it. So that's sort of where they're at, and everyone should know this, is that then that's who's writing these laws, are people that have that level of understanding, which is why the CAA doesn't work that great, and it has its problems. And, we're trying to sort of fill the gaps with it because it isn't perfect. And then you have courts, you can read a court opinion and it'll say things like self-funded plans design their own network and do, things that are just fiction that aren't really how things work. So I know I'm way off where the question was. I think it's great when an employer does do this. And I think really proper plan management, once we get everything else under control, would include helping your employees be more health literate and understand how to shop for things. But we don't even know how to do it right now. That's the reality, is that we're still trying to help the vast majority of employers become more literate in this. And I don't think they're in any position yet to be doing that for their employees.
Yeah.
Yeah. And Julia, I think you're exactly right. So you look at like Walmart. I mean, Walmart, I think, did Walmart within the past year or two, they basically, found 6 or 7 or 8 centers of excellence throughout the country. And then they would steer their surgeries to those places. But Walmart's a sophisticated, large, publicly traded organization. But, for the smaller employer with 500 employees or 1,000 employees, you may not have not only the muscle, but the expertise in order to steer people to the right place. Because you just, you don't have that kind of pull or information to know, what works and what doesn't.
Great point. And what about the duties of a TPA? How does the TPA interact with fiduciary duty?
Well, TPA is not a fiduciary.
Okay.
It depends. I think the TPA can be a fiduciary, particularly when it's an insurance.
If they want to.
And, in some cases, they are the claims fiduciary, like they name themselves the claims fiduciary. In that case, that's sort of slam dunk. They need to, handle claims like a good fiduciary. But there's the huge gray area. So say they're not a fiduciary, what are their obligations? Their obligations are based in contract and what you contract with them to do. And unfortunately, at least in my opinion, most of the administrative service agreements that plans enter are contracts of adhesion. It's very difficult to get a TPA to allow you to make changes that you should make to make this contract, make you be able to comply with ERISA. So you're either breaching your fiduciary duties or breaching your contractual obligations, because what you're signing doesn't let you do the things you need to do to be a good fiduciary. Doug, what do you think?
Yeah, I would agree 100%.
Okay, and what about the benefits advisor? What about the broker?
Wow.
Boy,
You go first, Doug.
I mean, boy, there are definitely, some very good, smart, honest, ethical advisors out there, but also by the same token, there's a lot that are not. And if you look at most advisor contracts, I mean, some will give you, the fiduciary status, but many don't, honestly.
Yeah, I think we'd be a lot better off if we changed the rules around what brokers were required to do. Whether, either they should be, and whether or not, I'm not saying that there shouldn't be a traditional broker system. I'm trying not to comment, my own personal feelings aside. You're either representing one side of the transaction or both. If you're representing both, then you're not a broker, or maybe that's what a broker is. And if you then you're only representing the plan side, maybe you're an advisor. But I don't think there's enough understanding that your broker really isn't always working for you, and that they might be getting paid more by the companies that they place you with than they're getting paid by you. And it's really problematic. And it's, is it their fault? No, this is the industry standard. There's not any sort of requirement as of now on even how you disclose sort of your conflicts. And that's why 408B2, which is this new part of the Consolidated Appropriations Act of 2021, was to add this requirement under all ERISA covered plans that brokers, consultants, and other covered service providers disclose all of their direct and indirect compensation to the plan. So what we've seen are brokers starting to make these disclosures, but they're not in a way that's really usable, and employers get this something that doesn't make any sense to them, because it'll have a formula. It'll say something like, this
exactly.
It's
like a formula from NASA. It literally takes a NASA scientist to figure out what are you getting paid. The law doesn't require specific dollars. You're getting paid X. It's a formula that you have to reverse engineer to figure out, what the compensation is. Because, Julie, to your point, to me, the real money's in the indirect compensation. It's not the direct stuff; it's the indirect stuff.
Yeah, and those indirect things that come to light all the time. That I would say, the things that I learn every day, the things I've learned this year, that multi-plans negotiation is basically sending a check to the provider and just saying, this is what you're getting. And there's nothing there that says you can come negotiate this with us. You can do anything else. And I've been dealing with that for, 30 years. So the other thing that I find so interesting, and that Emma Fox has really brought out in the past couple of weeks, that I knew about, but I didn't understand the depth of it, was clawbacks. And, we've got this payment integrity that a TPA is supposed to be doing. And literally, we had a TPA come to us with some cases where there were duplicate billing between Green Imaging and the facility. The facility probably had that patient's insurance on file already, didn't switch it to Green Imaging, and there was duplicate billing. They said they had no automated way to pick up duplicate bills. And so now they're coming back, and literally this is a clawback. I didn't realize they were getting to keep some percentage of that. Okay. And so, Julie, take that. That to me is
this is actually the bane of my existence. It's called savings fees, and you see them in a lot of different ways, but this is one of the most egregious examples. TPA pays a claim wrong, overpays, double pays, whatever, doesn't follow the payment guidelines. Then later finds their mistake in a claims review, a claims audit that they're doing, or you find it and bring it to their attention. And they then recover the overpayment and keep between 30 and 50% as a savings fee for fixing their own mistake. So this is absolute. I'm sorry, but if you plans have to stop agreeing to this. This is just an egregious breach of fiduciary duty. We actually just brought up savings fees and this particular practice in a lawsuit that we just we filed an amended complaint against Anthem in Connecticut on behalf of 2 labor unions, and we brought this issue into the litigation because there really isn't enough attention paid to it. Savings fees are always like, you know, sort of Orwellian speak, you know, it's like they're not really savings at all, and a fee for savings, but to pay someone to fix their own errors, and particularly some things that we then later learn in litigation or hear otherwise are maybe this facility was on a skip list the first time around, so they didn't even review the claim, and then when they go back and use their regular algorithm, they're going to charge you to adjudicate it properly when they intentionally didn't adjudicate it properly the first time. So that really is really just a problematic type of fee that almost every employer pays without understanding what it is.
Doug, any other examples of that?
Boy, saving fees. I mean, I can tell you just, I mean, it's pretty common, and Jill, you can confirm this, but it's pretty common where the savings that multi-plan or any other repricer earns is greater than what the hospital provided the service. So, examples of $10,000 CT scan, you reprice it to $1,200, but you're operating on a 25%, 30% savings. I mean, the repricer is going to get paid more than what the hospital did for actually performing the services. I mean, it's a completely upside down, ass backwards model.
Well, that brings one to light for me, and that's RBP, where we frequently see I'll skip the company name, fees, exceeding what the provider was paid.
Mm. Yeah, I think anytime that the fee for service exceeds the fee for medical care or medical treatment or medical services, there's a problem going on. And I think it happens all the time. And that multi-plan reporting in the New York Times showed, especially Cigna and United taking terrible advantage in these situations. And United Healthcare, here's an example of what they do. Not only will they take their savings fee when they fix their claims, they will send all out-of-network claims over to Data Eyesight. That's multi-plan's little negotiating, arm. And they will sometimes then reach a deal with a provider, and they will then charge you a savings fee based on. So, all right, here's an example that we saw in litigation. The original bill, it was for spinal surgery, and the bill was like $42,000. United literally discounted it to $1,200. The provider obviously appealed. It went to Data Eyesight. They agreed, the original bill was $110,000. They agreed to some amount that was like $42,000. And United first takes a fee on the difference between the full billed amount and the final the final amount that was agreed to. So that's not a rational nexus, but it's also not rational for them to have repriced it so low and it to go from there, because that's where the sort of multi-plans fees are based. And then after all this was said and done, they then took that money that they agreed to pay the provider and offset it in what's called a cross-plan offset, and said, by the way, this provider owes us money because we overpaid on a different plan, different claim. So yeah, you're authorized for this $42,000, but we're keeping it, and now you only owe us $8,000 more. So that screws the provider, the participant, and the plan, because their plan dollars, which are supposed to be used only to pay plan benefits, just went into United's pocket to fix a mistake United made in a different plan. It's insane.
Yeah, absolutely. Yeah, as a provider, that's just. And it's shifting gears a little bit to a very timely topic, since we had an independent TPA shut its doors last week. What happens? Say that happens. Is there any protection from ERISA for independent doctors and health plan solutions if a TPA or an employer shuts their doors? Doug, you want to start with that?
Yeah, no, there's not, unfortunately. Cash always works best, in my humble opinion. But I mean, if a TPA, shuts its doors, there's no obligation to the physician or the independent doctor. I mean, eventually, hopefully, you'll get paid. But if the plan sponsor isn't going to pay the bill, I mean, honestly, I mean, you're going to be stuck chasing that money. And it's a very unfortunate situation, but there's no protection that ERISA is going to offer the independent physician to make sure you get paid, unfortunately.
And I would add to that, obviously the plan is required to pay this. It's still their bill and the member has to pay their share. The plan has to pay its share. But now things are all, discombobulated because there's no TPA there. We don't know how much of the plan's money the TPA has and didn't pay. We don't know what claims are pending. So it's a big mess for a while. I do think there are numbers at EBSA. I'm not saying that this will work, but I do think that you can call EBSA and let them know that a TPA has sort of abandoned ship and that occasionally they will send in an independent fiduciary to help run out claims, particularly if the plan sponsor isn't working quickly enough to make things right. But if you have, thousands of claims because this TPA had lots of employers, I think it's worth a call to EBSA for sure. I think it's also worth a call to the state, depending on what state it's in. Even some insurance divisions do regulate third-party administrators as well and will at least try and step in and do something. And then there's legal action, but there is definitely no easy button to fix it. And it's a mess when things like that happen.
Yeah. And it's one of the things that as Health Rosetta is looking at this lead-like program for health plans is in some ways protecting the point solutions and independent doctors, because after this Change Healthcare debacle, independent practices are in trouble. I mean, I know a cardiologist in Austin who's been paid out his staff out of pocket for 3 months, was getting nothing in the bank. And it is just, we want to get these people back in. I got to go speak at the U of H Medical School to, on grand rounds and talk to doctors about getting out from under the broken system. But the problem is if the new system's broken too, we've got an issue there. I know we have some questions coming in the chat and some hands raised. Catherine, can you call on the people who have hands raised? Do you have that access?
Folks that have questions, comments.
Anthony Hartley.
Oh yeah, I do see Anthony. Yeah, I'm sorry, I do see that. Did you see the comments, Kristen, and messages? Yeah. Right. Okay.
Is Anthony on?
Hi, thank you, Kristen. Thank you, Catherine. I put my question in the text. It's really just it's not an easy question to answer, I know, but what is the standard criteria to determine whether or not a medical expense is reasonable? I know it's not an easy one to answer, but I imagine that this is going to get litigated a lot. Thank you for your time.
That's a great question. Go ahead, Doug.
I was going to say, it is a great question, because ultimately for something to be reasonable, there's got to be a market. There's got to be a market where, there's pricing stability. And the reality is we don't really have an open, transparent market. I think you're right. I mean, it's very difficult to determine what's reasonable, because what works in Chicago, Illinois, if you're paying a physician, may not work in, Houston, Texas. And so it's going to be all over the board, depending on where you are, the services that were provided. It's hard to say. And I agree. Great question. And not a real easy answer.
Yeah. And I would just add to that, there are a couple places you can look for sort of semi-benchmarking, at least something to tie it to. So obviously Medicare plus something is one way to try and arrive at a reasonable cost. The Fair Health database is actually a really good way, and it benchmarks usual and customary throughout the country. It's available to everybody, and it was the result of so this is a pretty funny story. Before MultiPlan and Data Eyesight began repricing, there was Ingenex, and it was which then turned into Optum after the settlement. But Ingenex used to have its own proprietary pricing database, and it would just reprice things very randomly, not based on any external benchmark. And eventually they entered into a settlement with the Department of Labor, and they were forced to not do that anymore and use this Fair Health database as a way to do repricing. And so that is why there was a shift away after that from usual and customary into all new areas of ways to repricing, because they didn't want to use that database. But it's still there, it exists, and it sort of has real-time price information for things, you know, and it's supposedly has every region of the country and it's broken down. So that seems to be a pretty decent resource, although I haven't personally used it myself, but I am aware that it exists and is available.
May I ask a quick follow-up question? Do you think maybe if there's a point of reference, if there's some kind of benchmarking possible, that's going to help those with the fiduciary duty? I know, for instance, in one of the recent cases, they were showing how rather than the employee paying the cash price, which was maybe $60, that employee was having to pay $10,000. Clearly, there's two different points of reference, and that's one way to determine, okay, well, that's not reasonable. What would you say?
Yeah, I think those are sort of the lower hanging fruit examples. If your plan is paying 10,000 times, 10,000% of what everyone else is paying for it. And I think that, in the PBM world, in the prescription drug world, there's a lot more benchmarking evidence available. You can, you can look at GoodRx, you can look at the Natick, you can look at Cost Plus. Everyone has prices available, so that's much easier than in the other side in healthcare and health facilities. But that's what we're going to get to, and that's what's happening now. And even with hospitals posting prices and other people posting prices, the more we do this, the more we will develop an active set of easily available and readily identifiable prices. So at least you'll know when you're in a mad outlier situation. There'll still be a range of reasonableness. Like, you don't always have to pick the cheapest thing, and the cheapest thing isn't always the best thing. You just can't pick things that are wildly outlandish. Or if something is more expensive, it has to be because it's higher quality, it's higher value, it's the only thing available. There has to be an explainable reason why you did that. And again, that brings you back to using a fiduciary process at all times to make all these decisions, because there is no sort of cookie cutter where you can just pick a price and go with it. Sometimes things might cost more, sometimes they can cost less. It's always going to be situation dependent.
And I would add, Julie, just, hospital financials are readily accessible. And if I was an employer, I would have every local hospital's financials, because those financials are going to show you, what that overall collection rate is, net other payers. Okay, so that's going to be self-funded, commercial, and self-pay. And so if you've got that information available, you'll kind of know, because it's also going to have the markups involved in all the different departments. And so you can get a feel for, what are you really paying relative to the hospital's financials. And that would be at least a good place to at least start, I think.
That's a really good point, Doug. Frank Cohn posted. Frank, you want to ask your question? I think the one about the employees on the benefits committee is a really good one.
Thanks, Kristen. Hey, everybody. Really appreciate the panel. Great discussion. I'm learning a lot. I have had some legacy customers in the past who've actually included employees on their benefits committee. Based on these, the way I've written this, the new risk in this fiduciary, lots of attention. Is it the wrong thing to do to place an employee on that committee, or is it better in the name of transparency that they are equally involved and might be a megaphone to the population, so it's fully transparent to their population? Any thoughts?
I think it's great. And I think, this is a decision every company has to make on their own. But the more diverse that committee is, the more, some people that are in the C-suite might not have the same concerns that, frontline employees have about deductibles, about, all kinds of issues. So I think it's a great idea to have a good cross section of your employees on that committee. As long as they're all properly trained in what they're supposed to be doing, I see nothing wrong with that. And I think it provides for diversity of perspective.
Yeah, and I think that's actually, common in the 401k world or 401k world. I mean, so, you're going to have employees involved, on that side of the ledger. So, I think it'd be a great idea in terms of the employee benefits as well.
Fantastic. And we've got Jim Jesko with a hand up. Hey, Jim.
Oh, thanks. Hey, thanks for great comments and a really good panel. If I'm an employer and building my own plan, there is this bold, someone commented on, I think it might have been you, Julie, bold conflict between my fiduciary obligation to manage assets prudently, pay only something that's reasonable and fair. Bold conflict between that and provider networks that have anti-tiering and steering clauses. I cannot say this hospital's too expensive, I want to put them on another tier or something like that. So is there any prospect that a legal action someday could have anti-tiering and steering clauses held invalid as a matter of public policy, because the stronger public policy is my recommendation?
That's happening right now as we speak.
Great.
Yeah,
that's
I mean,
awesome.
so I do a fair amount of work with, and Julie, you do too, with Fairmark, and so we've got a number of lawsuits challenging those exact clauses. I mean, so there's one antitrust case, actually there's two in Wisconsin, one against Aspirus and the other one against Aurora Advocate Atrium, alleging those exact things.
Yeah,
exact clauses.
And we work on that actually too. I think we all work together on that. But if you look at the Sutter Health lawsuit that already happened, they had to pay $575 million to the class action represented by a union plan, because they said these provisions in your contracts where these anti-steering, anti-tiering, exclusivity clauses are costing us more money, and this is an antitrust violation. And the Justice Department agreed, got involved, and they lost, and they had to pay a sizable settlement. So I don't know why it's not happening more. But it's starting to happen all over. And like what Doug said, the same types of claims are now being brought against Aspirus, against Atrium. It's happening all over the country. Atrium's a little more complicated because they're a so-called governmental entity spanning 3 states, but they're part of the government of North Carolina. But now the federal government is involved. And in fact, the North Carolina government has sued them. So this is going to start to get better over time. But it's pretty crazy if you think about it, that it's just sort of taken as a given that I can't carve this out of my plan because I'm not allowed. The network tells me I can't because it'll violate their contract with providers. Did you know that in 5 states, it's already illegal? In Texas, you can't have a contract like that. Texas, Connecticut, and there's another one. I'll look it up and tell you all who want to know later. And there's 3 more pending where it's already illegal to have anti-steering provisions in these contracts. So I would argue if I'm a plan in one of these states and I'm being told I can't carve this out, I'm like, well, of course I can, unless you're saying I can't, because it can't possibly be in your contract with the provider, because that's illegal. And in fact, Texas and Connecticut say it's not just illegal, it's void as a matter of public policy. So why can't I? So I think states are starting to do that, and the federal government is getting in on it. We're getting in on it in private litigation, and hopefully it's going to change soon.
Thank you.
Rena, you had a question about 501c nonprofit facilities refusing financial assistance. Are you still on? Okay, so here's her question. Any penalties for 501c nonprofit facilities refusing financial assistance to patients and only accepting 90% of billed charges as allowable, which is insane.
That is.
Oh, yeah.
Doug, you want to go first?
Yeah. I mean, so, you think about this. I mean, the way the law was originally established, it allowed the hospitals to define the parameters of financial assistance. And Julie, as you know, I mean, there's no uniformity at all across the country, either in the eligibility criteria, the application process. There's no appeal mechanism. I mean, it's a completely dysfunctional model. And, and I think everybody would recognize that many nonprofits are more profitable than a for-profit, and they certainly don't act like a not-for-profit hospital. But, when has the IRS ever, taken on a hospital? I mean, I don't know if it ever has. I mean,
yeah,
it's a complete legal fiction, truthfully.
I mean, technically you can lose that tax exemption, but I haven't seen it happen. I understand that is the stick, and that's supposed to be what could happen, but I don't know that it has happened. Why can't I find you guys anymore? I've lost my camera, but I do think that it's there. I think that, not charging more than AGB though, and not qualifying people, they should be reported to the IRS. And I think that just like with other issues, this is an issue that the federal government is waking up to. And I know that in particular, Bernie Sanders' Senate committee wrote a stern letter to a bunch of hospitals last year about not meeting up to their obligations for these tax exemptions. And we should be more active in the legal community of trying to strip hospitals that don't do the right thing of their tax exemption. I think the best law would be you are tax exempt to the extent that you give that amount back in charity care. So they should judge your prior year's performance. And if you only did 60% of what you were supposed to do, then you only get 60% of an exemption. I think there's no sort of carrot or stick to make this work, and we need to add one.
But you know, Julie, but it has to be at cost though, not charges. It has to be at cost.
Yes.
In terms of the charity care, exactly. You don't get to write off, you know, the $10,000 CT scan. You get to write off, you know, the $600 CT scan.
Uh-huh.
Yeah, we consider the ones in Houston real estate investment trusts. They have, you know, big people out in every suburb with this huge parking lot that's empty all day. It's really pretty interesting and frustrating and crazy.
Hey, could I tack on a quick thing about that? In addition to the IRS, there have been, I think, hospitals that have lost state and local tax exemptions. And there is a theory of attack that is just focused on state and local, and it doesn't have to be about the IRS challenging them. So
yeah, that's right. Especially California and Colorado and a few other states have heightened protections. Some states require all hospitals to offer financial assistance. So we can use state law and consumer law, sort of consumer laws and things like that. You can be a lot more effective.
Do we have any other questions? I think we've had an amazing conversation today. Mark Fox.
Yeah, I appreciate the panel. This has been amazing. It seems to me that, and maybe it's just because I'm a novice, but it seems to me that there's a conflict between fiduciary obligation and HSA law, being that the fact that HSAs and the way the law is written seems to be a bit of a border and something that's preventing first dollar coverage from employers, and they're using first dollar coverage to negotiate with providers. And so some providers won't allow certain discounts because now they're in the collections agency of, you know, getting that deductible, right? So where is the line drawn from the fiduciary getting a better deal by covering 100% of it versus them losing their qualification of being in an HSA plan?
Great.
You know, that's a great question, Mark. You know, and I would say this is that, you know, the regulations really haven't caught up with what the market is doing right now, because I know there's a lot of organizations out there that are actually, you know, utilizing first dollar HSA coverage. But to me, it's really kind of, you know, it's a risk versus reward thing. I mean, is there really any HSA police out there? No, there's not. So, you know, if I was an employer, I would seriously look at, you know, employing one of those strategies, but understand that there's some risk, you know, there's just no enforcement.
HSAs are actually not subject to ERISA. And so that is problematic. They're not governed by ERISA. You don't have to disclose them on a 5500. And so they don't have the same, whether or not the obligations are the same, if there's no one there to enforce them, then are they? You know, that's the problem.
Mark, we have a member of this chapter who had a really great idea, who actually has two similar plans that he offers that are, you know, that are qualified high deductible healthcare plans, because in Texas, that's the least expensive catastrophic plan, but he only qualifies one of them. So that group, the people who opt into that group can actually, you know, have the zero out-of-pocket options that he has together. If it's really somebody who wants that HSA as a savings vehicle, they're subject to that statutory minimum deductible. And so I think that's a really great tool. There's some other hacks for this. JP Farley actually W-2s the member because it's only that it is taxable. The regulation of that is that it should be taxable income. And so that way the employer is still giving first dollar. The member is, you know, maybe pays 20% of that. So I thought that was a really creative idea.
Yeah.
Thank you.
Anybody else? Well, I want to thank everybody, especially Doug, Julie, the fantastic conversation. Thanks to everybody for attending. That's what makes it great. And for all your great questions and comments. And we'll be doing this again and look forward to seeing you next time.
And thanks for having us.
Yep, thank you.
Thanks, everybody. Bye.
All right, you guys have a good day.
Thank you.
Goodbye.